The chairperson of the inquiry into Advocate Busisiwe Mkhwebane's fitness to hold office, Richard Dyantyi, says he will not recuse himself. Mkhwebane accuses Dyantyi of bias. Let's talk about the latest developments now with Advocate Paul Hoffman. A very good afternoon to you, Advocate. Paul Hoffman is Director at Accountability Now. Thank you for your time. Has Richard Dyantyi made the right call here?
Yes, good afternoon, Tembakili, and good afternoon to your viewers as well. Thank you for the invitation. It would seem to me that Richard Dyantyi and also the Member of Parliament on the committee who's also been accused of bias, Mr. Milam, they've both made the right call as far as I can see. There's no basis for asking for their recusal, but that will not deter the Public Protector if she runs true to form. We can expect that she will make an application to review their decisions not to recuse themselves, and she will couple that application with an application that asks that the entire Section 194 inquiry be put on hold until there is a final determination of the review case. And when she talks about a final determination, she means after an appeal to the Supreme Court of Appeal and a further appeal to the Constitutional Court, possibly even a rescission application when the Constitutional Court also tells her what I've just told your viewers, which is that there is no case for a recusal of Mr. Dyantyi or Mr. Milam.
Well, Dyantyi, in one of his interviews, has in fact said it's time for Advocate Mkhwebane to now state her case 3 months into the hearings by this impeachment inquiry. If things go as you are predicting, which they are most likely to go, do you think this committee will actually get to having Advocate Mkhwebane sitting there facing questions anytime soon, especially when you consider that she's in the final stretch of her term as Public Protector anyway?
Yes. Now, her deadline is October next year. That's when her term of office expires. And if the recusal application and the interdict do not work, I think they will struggle, even though they only need to show a prima facie right in the interdict, in the temporary interdict proceedings. I think they will struggle to persuade a court to give them a temporary interdict. But if she gets the temporary interdict, she will play out the review proceedings through all of the appeals that I've mentioned, and she will reach October and the end of her term of office quite comfortably.
And what is the attitude, the feeling of this country's courts when it comes to bias, whether confirmed or just perceived bias? Because perceived bias often, especially in the public domain, goes a lot further, does it not? Yes.
Now, the test in law is whether it is a reasonable perception of bias. In other words, it can't be any one-eyed look at the conduct of the chair and of Milam as to whether or not they are biased as such. The test that the court will apply is, would a reasonable person suspect them of bias? Now, Milam is accused of being condescending, which means that he has used kid gloves on counsel for Mkhwebane. And Richard Dyantyi has really simply tried to keep control of the proceedings which he is chairing. And you don't get a smell of bias out of that, and you certainly don't get a reasonable perception of bias. And if the courts agree with that approach to the facts that are put before the courts, then they will say, we are not giving the interdict and we are not granting the review. And that is the outcome that can be expected every step of the way. But it is an exercise that will buy a great deal of time for the Public Protector. Unless, of course, the registrars of the courts, the High Court in Cape Town, the Supreme Court of Appeal in Bloemfontein, and the Constitutional Court in Braamfontein put their heads together with a view to case managing the matter in a way that brings it to finality with the minimum of delay. This is the answer to the Stalingrad strategy that is so often employed in politically charged litigation in South Africa. I think former President Zuma is a champion of delaying tactics, and certainly in this matter, the Public Protector is taking a leaf out of his book with a view to spinning the matter out.
What then, Advocate Hoffman, is the potential of all of this as far as tainting the credibility of this inquiry process in the eyes of the public? Because the courts can pronounce one thing, but if people themselves are not convinced that the committee has run its business in a proper way, that is a problem.
I think that the people of South Africa know that the Public Protector is a deployed cadre of the Zuma faction. President Zuma made a terrible mistake when he appointed Thuli Madonsela as his first Public Protector, and he was quite determined not to make the same mistake again. So a lot of the work that has come out of the office of the Public Protector tends to suggest that she is supportive of the RET faction of the ANC, and that is not what is expected of a Public Protector. Public Protector ought to operate without fear, favour or prejudice. In other words, independent of
Advocate Mkhwebane will argue that she does, and that she's now being punished basically for being a Public Protector that is anti the mainstream, shall we say, narrative around whether this current government is better than the previous one, being a pro-black Public Protector, for example, going for cases that previously would have gone unchallenged. That's what they will argue.
Yes. No, certainly the indications are that they will argue anything and everything in order to make the case last until the end of her term of office. And that seems to be the tactic, and you don't do that, you don't get involved in that sort of tactic if you think you have a good case. You put your head down, you explain your defense, and you get on with the case. That isn't what's happened with her. She's litigated every point along the way, the rules according to which this has to be done, and the validity of her suspension, and the question of whether an appeal should prevent her from returning to the office after some judges have been persuaded that the suspension was not a valid suspension. All of that has the hallmarks of a huge Stalingrad strategy designed to make this dispute last until it becomes a dead letter in October next year.
All right. Advocate Paul Hoffman with Accountability Now. Thank you for your time.